Good afternoon, ladies and gentlemen. Very good to see so many of you here. I'm delighted to welcome Tobias, who has recently moved from Edinburgh to Maynooth, which is a new university in Ireland, and he is going to talk on the subject about which he is the most expert, namely fundamental rights, and revisiting the question of whether there should be accession by the EU to the ECHR. Tobias, thank you very much.
Thank you very much. Thanks, Catherine. Thank you, everyone, for coming. Thank you for having me. The last time I was in this building, I did a job interview. I didn't get the job, so you know. Now I'm here. Leave us motivated, but I won't be disappointed after. Now, thank you very much. So, EU accession to the ECHR is on the table again. I have to discover, unfortunately. The EU Commission published a paper on the rule of law and all sorts of things that concern the EU nowadays, apart from Brexit. And one of the things they still want to achieve is the EU's accession to the ECHR. It's of course never gone away. It's been a topic for the last 40 odd years or so, since the late 70s. And it was knocked back twice by the Court of Justice in opinion 294 and 213. Now, I used to be quite in favour of it, I must say. I wrote about it, so you want to be in favour of something you didn't write about, or you want to be dead against it, otherwise it's no fun. And I was surprised at the time by opinion 213, which robustly rejected any attempt at getting the EU to become a party to the ECHR formally. And the reason why I was surprised and a little bit annoyed by it was because the Court of Justice basically made it almost impossible for the EU to do so without the ECHR changing fundamentally. And now that the topic is back on I actually swore I'd never write about it again because, but the topic is back on the table, and somebody asked me to contribute something on the future of EU human rights law, and I thought, well, I might as well revisit this. And I did a bit of digging, and I came across interesting cases in the area of freedom, security and justice, EU criminal law, EU asylum and refugee law, where I think the ECHR has done an awful lot of good for human rights in the EU, which would not have happened without it. And I would also argue which would not have happened had the EU acceded to the ECHR under the conditions formulated by the Court of Justice. And that's what I'm going to try to explore now. And that's which is why I'm going to argue that we should think very, very hard. The EU should think very, very hard, and the ECHR system, the Council of Europe, should think very, very hard as to whether this is really a good idea. Okay. Now, why are people still in favour of it? Now, the argument was captured quite nicely by Johan Kalevaar in the Common Market Law Review 2018, where he picked this topic up. Johan is a deputy registrar at the Grand Chamber of the ECHR. And he says basically three reasons. The first is that we have a wrong attribution of responsibility under the ECHR at the moment when it comes to EU law infractions. The second reason is that there is a bit of confusion, the potential for fragmentation, all of that in the EU-ECHR relationship. And the last, excuse me, I need some water. And the last argument is that it's the Cambridge cake. It's tickling me. The last argument is that it would help to strengthen the system of human rights protection in Europe as a whole. If the EU finally signed up to to that other big body of European integration, the ECHR and the Council of Europe. Now, and I think that pretty much reflects the thinking, I think, at the Court of Human Rights. Yeah, it probably reflects the thinking in many quarters of the European Union. At the moment, in order to understand this, I think we need to take a step back and look at what the current EU-ECHR relationship is. There are two themes running through it. One is a theme of fragmentation, inconsistency, or potential for fragmentation, inconsistency and fragmentation. And the other theme is are accountability gaps for EU action. On inconsistency, we've currently got two partly parallel systems where the ECHR guarantees the same rights as the Charter of Fundamental Rights. Yeah? We therefore have two different courts interpreting these rights. And of course, these two different courts can come to different conclusions as to the scope of the rights and as to the proportionality of any types of interferences with them. There is some unilateral coordination happening in two ways. One, we've got a formal mechanism in Article 52.3 of the Charter, which says rights that are corresponding to the ECHR have to be given the same meaning and scope as the ECHR rights. So the ECHR is a minimum standard under the Charter. And there is plenty of evidence that the Court of Justice takes inspiration from the Court of Human Rights. There's also evidence, I think, that the Court of Human Rights even takes inspiration from the Court of Justice. So everything seems to be going okay. However, this coordination does, of course, not always work. If you look back at the 1990s, when people started writing about this en masse, they had two particular bugbears. One was the question whether companies had a right to a home under Article 8 of the ECHR when they were being searched by the Commission in competition cases. The Court of Justice said no. The Court of Human Rights suggested that maybe yes. And the similar question arose whether companies had a right to silence when they were being questioned or when their representatives were being questioned by the Commission. Yes or no. Again, something both courts did not really agree upon. That has mainly been sorted out as far as I can see. I have found a new one, a new problem, which I think is a bit more problematic because it's actually about human rights and about companies' rights. And that is the example of double jeopardy, or nebis in idem. Now, Article 50 of the Charter and Article 4, Protocol number 7 give us a right not to be prosecuted and sentenced twice for the same crime. Yeah? Fairly fundamental right. Article 50 corresponds to Article 4, Protocol 7, according to the explanations to the Charter. But there is a case that is called Menchi, which is not very famous and shouldn't be, but apart from this particular issue here, where we can see certain tensions between the interpretation given by the Court of Justice and the interpretation by the Court of Human Rights. And I think these tensions are important because Article 4, Protocol number 7, ECHR, protects an absolute right to not being prosecuted twice. Yeah? There's no exceptions to it. Not even in case of an emergency under Article 15 of the Convention. No exceptions whatsoever. And the same should be true for Article 50. Yeah? Same meaning and scope. Now, if you look at the case of Menchi, where we have essentially the same legal question as in Ackerberg Franson. It was about whether if you haven't declared your VAT fraudulently and you are levied with an administrative fine by the tax authorities, whether you can then still be prosecuted criminally afterwards. Yeah? He says, no, I can't, because I've already been punished once. I had to pay this fine, and I can't therefore be prosecuted. Now, it is obviously for the National Court to decide this, but the Court of Justice said, well, in this case, there are strong suggestions that this administrative fine imposed by the tax authorities was so punitive that it amounts to a criminal sanction. And therefore, Article 50 kicks in. Yeah? One prosecution, or one type of penal punishment, and then, on the other hand, we've got the prosecution happening at the same time. However, that should be the end of the story. Yeah? Win your case, absolute right. Interference with the civil. The Court of Justice then said, well, maybe this can be justified, and they point to some case law of the European Court of Human Rights, which says nothing about justification, because the European Court of Human Rights maintains it's an absolute right. And they said, on those circumstances, we can maybe justify the second prosecution. Yeah? I've just paraphrased. Not important. But what is important is that there seems to be disagreement about whether Article 50 is an absolute right or a relative right, and that is really important. So there are cracks in the system, as it is at the moment. So good argument for EU accession. We might be able to sort these things out. Yeah? And of course, there are also accountability gaps at the moment. The rule in Matthews is that the EU itself cannot be held responsible for any violation of the ECHR brought about by EU law, but the member states can instead. The member states may well transfer powers to the EU, but they remain responsible for what the EU does with those powers. It makes a lot of sense. So Matthews is widely accepted. There are two exceptions to it in the court's case law, in the Court of Human Rights case law. First is Bosphorus, where a EU member state implements EU law and has no discretion whatsoever. The Court of Human Rights says, well, the EU protects fundamental rights in a manner that is equivalent to the Convention. It's equivalent to what we want. The member state has no discretion. We therefore presume that the protection offered by the EU was compliant with the Convention. Yeah. This presumption can be rebutted in the individual case if it can be shown that there was a manifest deficit in the protection. So presumption of equivalence, presumption of protection, if there's no member state discretion, if the member state can't mess around, basically. Yeah. And rebuttal in extreme cases. First exception basically means that in cases where there is no discretion for member states, an individual applicant is not going to win their case in Strasbourg. Yeah? No way. Yeah. And as far as I know, they've never won a case of that kind. The second exception is what is called what I call the Connolly gap. Sounds like a hiking route or something, but it's not. Connolly was famous, I suppose, in the 90s or so in the UK. He was a commission official, was sacked by the commission for misconduct. He complained that this was, unlawful and so on and so on, brought his case to the Court of General Court, Court of First Instance at the time, then that went up to the Court of Justice. He lost, and he lost again, and then he complained that the procedure before the Court of Justice was in violation of his right to a fair trial. Yeah? And the procedure before the Court of Justice, we don't know whether it was or whether it was not. The Court of Human Rights simply didn't accept the case as admissible because it said this is not in the jurisdiction. This violation, this alleged violation, did not happen within the jurisdiction of any of the EU's member states because none of their institutions, none of their officials, nobody was involved in the matter. It was a purely internal EU matter. Yeah? Commission sacks him, he goes to an EU court to get his remedy, he loses, no member state was ever involved, no member state got its hands dirty. Second exception. And this might be, not confined to, I think, not necessarily confined to these staffing disputes, but it could also kick in competition law cases, for instance. Yeah? But, or perhaps missions, EU missions abroad. But, as the EU doesn't have its own soldiers, probably not. Now, why does this matter? So this is what the law is at the moment. Now, little jump. Where might this become problematic? If we have EU accession, obviously, these gaps would be closed. We would probably have less fragmentation as well. Yeah? That is the argument for accession. The problem, there's a price to be paid, however, and that is in the area of freedom, security, and justice, which works in its own peculiar ways. Now, in the AFSJ, I think it's probably the most exciting area at the moment in terms of growth in the EU and EU law, apart from Brexit, of course. But outside of these islands, it's probably the most exciting area is the AFSJ. It's the second busiest area of ECJ activity. 82 new cases last year. 80 of which were preliminary rulings. That goes to suggest that this is just the tip of the iceberg, that thousands of cases decided at the national level that never make it to Luxembourg. It's a huge area in terms of human rights sensitivity, of course, as well, because much of the AFSJ is to do with criminal law, with refugee law, with people being sent back to a safe third country, people being put in jail in Bulgaria, and so on and so on. The AFSJ is based largely on the principle of mutual trust, mutual recognition. Mutual recognition comes, of course, from free market, internal market law, and it basically means we recognize each other's standards. We recognize each other's fundamental rights standards. each other's procedural standards, and we cannot question them. So a person who is subjected to a European arrest warrant in Ireland and faces surrender to Austria cannot say, I don't trust the Austrian system of fundamental rights protection because, point to case law where they don't respect, I don't know what his specific demands are. Yeah? It's not possible. That will be unsuccessful because of mutual recognition. The Court of Justice will say, well, you can't challenge this in Ireland. You have to wait until you've been surrendered to Austria, and then you can challenge it there. Yeah? Or you can go to Austria straight away and challenge the original warrant, if there's a remedy against it. But you can't do that in the executing member state. And the same goes for asylum seekers. Yeah? If you're an asylum seeker and you've somehow ended up in Ireland, yeah, and you don't want to be, but they want to send you to Greece or to Italy, and you really don't want to go there, you can't invoke the fact that, say, success rates for asylum are much lower in Greece than they would be in Ireland. Or you can't say that, I think the Greeks are not going to respect my right to freedom of religion adequately. Yeah? That's not going to work. You will be sent back, mutual recognition. You have to challenge in the member state. And that, of course, leads to problems because, it may simply not be true that protection of fundamental rights is as good in another member state. Yeah? And people might fall between the cracks. But that is how the AFSJ works. And that is why it is important for fundamental rights protection. And of course, there is plenty of ECHR case law, a huge amount, on extradition and expulsion. Yeah? The European Court of Human Rights has a very, very long line of case law on the expulsion of unwanted individuals to third countries where they might be facing torture or inhuman and degrading treatment or even unfair trials. Yeah? Think of Abu Qatada, if you remember him, who was one of those spectres that went through the media a couple of years ago. Think of Mr. Surin, who was the first fellow, who was facing the death row in America and who could not be extradited until the Americans said they were not going to seek the death penalty for him. He's just got out of prison. He's back in Germany after 40 years or something. So there's a long line of that kind of case law about transfers of people, coercive, involuntary movement within the EU, if you want to call it that. Yeah? Now, mutual trust featured very big in Opinion 213, which was a huge surprise because, as far as it didn't feature in the accession agreement at all. Nobody saw this one coming. It didn't feature in the Advocate General's opinion. As far as I know, it didn't really feature in the oral hearing either. And the Court of Justice said, nonetheless, they said, well, it must be prevented, yeah, in any future relationship between the EU and the ECHR, it must be prevented that the EU and member states are considered contracting parties, not only in their relations with contracting parties which are not member states of the EU, but also in their relations with each other. So it must be prevented that, for the purposes of the convention, the member state A, Germany, and member state B, France, are considered to be contracting parties of the convention, that is, responsible under the convention, if we're dealing with a case of surrender of one individual from Germany to France. Yeah? That must be prevented. Why? Because this would undermine mutual trust between those member states, yeah? Including where such relations are governed by EU law, and require a member state to check that another member state has observed fundamental rights, even though EU law imposes an obligation of mutual trust between those member states. Why? This would upset the underlying balance of the EU and undermine the autonomy of EU law. Now that was a big deal, yeah? Because if this is one of the most fundamental rights sensitive areas, and the Court of Justice is telling us, well, yeah, you can accede to the ECHR, but you have to exclude that from review by the Court of Human Rights, the question arises, what's the point, yeah? Now, how can you exclude it? It's not that easy. I'm not a drafts person, but drafting an accession agreement such as this is tricky. And the main problem, and I don't want to go into any detail, but the main problem is not to get into trouble with the autonomy of EU law, which is one of the key newer themes in EU constitutional law, let's say, of the last 10 years or so. The autonomy of EU law says, amongst other things, that EU law can only be interpreted by the Court of Justice, provided it is binding on the members of the EU. Only the ECJ can interpret it in a binding manner. And that, of course, means that any clause in a withdrawal agreement, in an accession agreement, that says, oh, well, wherever the member states are acting under the obligation of mutual trust, and so on, the Court of Human Rights shall not have jurisdiction, is problematic, because it would require the Court of Human Rights to decide, are the member states acting under an obligation of mutual trust, or are they not? And that is a question of EU law, which has no power, cannot be given power to decide upon. So we need a broader clause. That would be my solution. I don't know how to ask the question, but I think a safe clause would be that member states of the EU cannot be held responsible under the Convention for failing to carry out a review of another member state's compliance with Convention rights. That's broad. It's broader than it has to be, but it's so broad because otherwise we get into trouble. Anyway, you may criticize me for this. So that would be the consequence of accession. Member states cannot review each other's human rights compliance or cannot be asked to review each other's human rights compliance as an obligation under the Convention, and therefore any case brought by an individual claiming that a member state has failed to carry out a review of another member state's compliance has to be declared inadmissible. Okay? Now, is that a good thing or not? I think it is a bad thing. The reason it is I'll give you two examples where I think in the AFSJ we can see actually relatively positive developments without EU accession, which have led to tangible changes and a certain mellowing on part of the Court of Justice of the rigid mutual recognition rule. First example, where you can see this very clearly, is with asylum seekers and refugees. Now, under the Dublin regulation, there is a Dublin 2 regulation which was replaced by the Dublin 3 regulation, but the rule is the same. A person who arrives in the EU claiming asylum has to claim asylum in the member state where they first set foot on EU soil. Yeah? Most of them, surprise, surprise, arrive in Greece and Italy and Spain, the southern border of the EU, and not in Sweden or Ireland, or the UK for that matter, still. In MSS versus Belgium and Greece, this unfortunate individual arrived in Greece, and the asylum, the reception conditions were abysmal at the time in Greece. People were left without any help, in destitution. They had to live out in the streets, eat rubbish, I don't know, whatever. They had no way of actually applying for asylum in practical terms. Yeah, the police station that was there in Athens was open like on a Saturday from 10 to 12. So it was an awful situation for these people to be in. So this fella, somehow, probably by people smugglers, made his way to Belgium and applied for asylum there. The Belgians said, "Bienvenue, mais non." Yeah, sorry, you have to go back to Greece. Yeah, welcome to the EU, but you go back to Greece and get your case heard there, and they will sort you out because their protection is as good as ours. Mutual recognition. Thank you. Now he complained, and he went through the Belgian courts, and the Belgian courts said, "Well, mutual recognition, sorry, go back to Greece." He went up to Strasbourg, to the Court of Human Rights. And the Court of Human Rights applied its extradition case law and said, well, we can't extradite somebody if they're facing a real risk of being subjected to Article 3 violations, inhuman, degrading treatment or punishment. And the conditions in Greece were such that they crossed the threshold, and they were so bad that it was an Article 3 violation, and therefore Belgium was forced to not to examine the asylum application, but to keep the person in their country, not to send them to Greece. That's what they were not allowed to do. Good. A year later, NS came about, or maybe 2 years later, I don't know, which was an ECJ case, that's why it's blue. Yeah, blue is EU, yellow is ECHR, where the Court of Justice had to deal with exactly the same issue, exactly the same question. only that the person had ended up in the UK somehow, and nobody knows why or how. And the ECJ became convinced that there should be an exception to mutual recognition in those cases. Now, they were able to base it on the legislation because the Dublin regulation contained a clause that gave member states discretion to examine asylum applications, even where the person had, first registered in another member state. So it wasn't quite an extra legal type of remedy. So they were able to squeeze it into the law somehow. But still, the ECJ went along with the European Court of Human Rights and quoted the European Court of Human Rights. And the situation changed a little bit. This was then codified in the Dublin III regulation. Now, the ECJ did one thing. They interpreted MSS very, very narrowly. They said it only applies where there are systemic deficiencies in the protection in the member state concerned. Yeah? Systemic deficiencies in Greece. They were systemic. That's not something the Court of Human Rights ever said in MSS. Yeah? Well, ECJ thought, well, we might get away with it. They got away with it because that's how it was codified in the Dublin III regulation. But then came Tarakel, where the question was about surrender or return of a person to Italy. Now, Italy does not have any systemic deficiencies in its reception condition, yeah? But they have deficiencies in certain types of accommodation. Yeah? Now, Switzerland is bound by the Dublin III regulation. Yeah? They've signed up to it, even though they're not EU member states. And Tarakel, the European Court of Human Rights, said, well, we have to look at the individual case. Yeah? It's not enough to just narrow this down to cases where there's systemic deficiencies, because, frankly, for the individual, it makes no difference. Yeah? I mean, whether I'm being inhumanly treated because there's systemic deficiencies or whether they just want to punish me, I mean, that doesn't really make any difference to me. It's still an Article 3 violation. And that seems to have been the thinking on part of the ECHR. And they said, okay, every type of Article 3 violation will trigger an obligation to not expel or to not surrender the person to another state. And that was again picked up by the Court of Justice in a very different case, the CK. It's not about accommodation of asylum seekers, but CK was a very unfortunate individual, was very ill, both physically and as a consequence, as far as I can tell, she also developed mental health problems. And she was supposed to be sent from Slovenia to Croatia. And under the circumstances, the Court of Justice heard that even the transfer would be so traumatic that it would amount to a Article 3 violation, or Article 4 in the Charter is the same thing. A violation of the fundamental right not to be treated inhumanely. And therefore the Court of Justice said, no, we have to make an exception here. Slovenia has to keep that person in the country. They can't send them to Croatia. We can see here how the case law really clicks in. There's a nice ping pong, the ECJ receiving the message from the European Court of Human Rights and complying with it. In the area of EU criminal law, which is as important, I suppose, in terms of case numbers and all of that, the story is not quite as straightforward, but I think I can present some exhibits why I think something similar has happened. Now, European arrest warrant cases don't normally make it to the European Court of Human Rights because of bottlenecks. In a European arrest warrant case, the executing member state, the member state that is asked to surrender an individual that they have arrested, has no discretion whatsoever. Yeah? The European arrest warrant, if it is formally compliant, has been issued by a judge and so on, a judicial authority, whatever that is, and so on and so on. And if there are no mandatory grounds for non-execution, has to surrender that person. That's it. However, and therefore, they have no discretion, therefore Bosphorus always kicks in, and therefore you don't have a chance in Strasbourg. But one case made it there, just in the aftermath of Opinion 213, when everybody was terribly upset at the Court of Human Rights. Yeah? They were personally, I think, upset. I think it's fair to say. There's a Brussels 1 case. Brussels 1 is about the execution and enforcement of civil judgments. Yeah? It doesn't matter. Mutual recognition works there as well. Here, Abotinj was in Latvia, and he was a defendant in a case in Cyprus. The problem is that the summons never reached him somehow. The Cypriots didn't care very much. They handed down default judgment, which became res judicata, and which was then being enforced against him in Latvia. Now, all of a sudden, he realizes, oh, I have to pay. I don't want to do it. I think my fair trial rights have been violated in Cyprus. And he's bringing that case in Latvia, not in Cyprus. Now, the ECJ's standard answer to these kinds of cases would be, well, you have to go to Cyprus to challenge this. Yeah? But he wants to challenge it in Latvia. He loses, and the case ends up in Strasbourg. Normally, as I said, in these kinds of cases where there's no member state discretion, the European Court of Human Rights would write a very short judgment and say, equivalent protection, no discretion, no manifest deficit, you lose. Inadmissible, manifestly ill-founded. Yeah? In this case, they thought, well, it's a good opportunity to say a few things, and they actually examined whether the human rights protection in EU law under the Brussels I regulation was manifestly deficient. So they went into some detail. That was very unusual. And they criticized the ECJ, of course, for its opinion. And they said that one cannot simply refrain from examining human rights issues just because of mutual recognition. That's basically the bottom line. Okay? And then the Court of Human Rights was being nice again and said, but there was no manifest deficit here anyway, so no, sorry. So Abotinch lost now to pay. But a few years later, the famous Aranosi case came about, where Germany was asked to execute 2 European arrest warrants and surrender these 2 fellas to Hungary and Romania, respectively. They both were able to show or to demonstrate that there's a problem with prison overcrowding in those 2 countries and with bad prison conditions. And there are thousands of ECHR cases on prison overcrowding, yeah? Especially in Russia, but also in other countries, Ukraine, and bad prison conditions as such. They are Article 4 violations, and if you ever read one of those cases, it's actually quite interesting because it's very mechanical. Yeah? You have spent more than 20 days in under 3 square meters for like 23 hours a day, you win. That's the end of the case. It's very mathematical. The computer could deal with these cases. It probably does. So, in Aranosi and Calderaro, again, German court sends reference to the ECJ. Do I have to send them to these awful prisons? And the Advocate General Bo, who is unfortunately deceased, but he used to be a criminal judge, I think, in his former life. And of course, he had not much sympathy with these people. He's like, hang them dry. Well, if we did that, the whole European arrest warrant system would collapse. Now, that's not a good argument, is it? Consequentialist arguments don't really work well in human rights law, or shouldn't. So he didn't get through with his arguments. But what happened was the ECJ said, well, if there is a real risk of these people ending up in one of those prisons, and that is, for the national court to determine, so who knows what happened, really. But if there's a real risk, they can't be sent there. Yeah? The way out is, of course, for the member state to guarantee that they won't be sent to one of those prisons, that they will be sent to one of the nice ones. Yeah? Nice. In inverted commas. But here we have an exception to mutual recognition in the European arrest warrant that is not in the law. It's not part of the European arrest warrant framework decision or anything. Yeah? And another chink in the armor was LM, or Chelmer, as its real name is. It's an Irish reference which will come back. I mean, that kind of set of facts will come back, I'm sure, relating to the independence of the judiciary in Poland, where somebody was subject of a European arrest warrant, asked to be sent to Poland, and he said, well, I can't trust the judiciary there. I don't know whether I'll get a fair trial. Yeah? Because, the judges are in the pockets of the government. And that is probably more truer now than it was then. And the Court of Justice said, well, in certain circumstances, if there are substantial grounds for believing that the person will run a real risk of a breach of their fundamental right to a fair trial, so we're away from inhuman or degrading treatment, we're now at fair trial. wouldn't say a lesser human right, but it's at least a relative human right, not an absolute right, then we can make an exception in the EAW. Now, what can we conclude from this? I hope I've shown that the European Court of Human Rights case law has had an influence over the ECJ softening. And why is that? I would argue because we've got this Damocles and the sword is hanging over him. And that is the manifest deficit threat. Yeah? There's the threat of being hit on being wrapped on the knuckles by the ECHR, which the ECJ doesn't want to see. Yeah? They don't want to be seen not to be protecting fundamental rights. They're clearly not a human rights court. They're more than that. Yeah? But they don't want to be seen to be violating human rights. So what if accession took place? Well, my new clause in the accession agreement, we can't review these matters. Yeah? MSS would not be in the court's jurisdiction. You lose. Challenges via EU law would of course remain possible, and national courts could still refer these cases to the ECJ, but the big question mark is, would the ECJ have changed its case law? I'm not sure. I don't know. Genuinely. Yeah? Absolutely open. Yeah? Who knows? They might have. They mightn't have. Tarakel versus Switzerland was a Swiss case. Well, they still changed their case law because they knew it applies to them as much as it does to Switzerland. That problem. A Swiss case could come up any time, even after accession, and deal with these issues. So my question is EU accession still a good idea? Or is the pluralism that we have today, this pluralistic relationship of trying to arrange one another's different viewpoints and working it out in a somewhat messy manner, is that maybe better? I think accession would come with risks, the risk of a regression of overall standards, but also, and I think that is something the proponents of accession don't quite maybe realize, undermining of the ECHR system as such, because it would introduce two types of ECHR members. It would introduce member states of the EU that would be immune from certain types of review. It would introduce others, some of whom are also bound by EU law because they're in the EEA, Norway and those, and Switzerland, quasi. And they're part of Schengen, part of the Dublin system, and all of that. Norway has just signed a European surrender warrant agreement with the EU, which will introduce something very, very similar. And if the EU member states are seen to be given a special status, that is not very popular. Also think of your own country, no longer an EU member state, presumably no longer bound by the EU asylum system for a while anyway, until the government comes to its senses. I wouldn't go down too well either. Yeah? UK will be held responsible for things that the EU member states wouldn't be held responsible for. Is pluralism all that bad? I can't believe I'm saying this, because I'm not a pluralist. But historically, I think it's clear that pluralism has often preceded constitutionalization. Yeah? There had to be mess first, and then we realized that something constitutional, something more formal is better. But also, I think people should be wary of the fact that constitutionalization or formalization of relations is not an end in itself. It has to serve for something better, a higher purpose. And I don't think that is obvious right now. So that's where I'm at. You done? Yes. Thank
you very much indeed. It's a reminder that we all need to get out and have another look at Opinion 2 of 13 that has been it's tucked away, and actually we don't even really teach it anymore at the moment, so we have to have another look at it. Do you have any questions? Go, Kieran. Anyone else got any questions? Okay, Kieran first.
Okay, thank you very much, Tobias. That was most enlightening. I just one question that I wanted to ask you concerning. You said at one point that under mutual recognition in the European arrest warrant scenario, you could only challenge any breach of your fundamental rights in the receiving member state. So did I get that correct? So in other words, you can't challenge your surrender in, say, Ireland if you're going to Austria.
Yeah.
You wait till your fundamental rights have been challenged, have been not respected, then you challenge them in Austria. Is
Yeah,
that
yeah, that's what I'm
so yes, I understood that to be the position in principle. So how do you personally react to the decision in RO? I hate to bring in Brexit, but in RO the court said, oh, it's okay even if the UK is no longer a member state. You'll presumably be able to challenge your fundamental rights and challenge any breach of your fundamental rights in the UK courts. So that slightly undermines. I mean, if the principle is you challenge them in the receiving member state, this would be the UK, which will no longer is no longer a member state.
Well, I mean, so if I'm in Ireland and I'm wanted here because I committed a crime today on my way home, and then I say, well, I'm not going because of Brexit.
That's what
our
argues.
Court of Justice says, well, you have to challenge it in the UK.
In the UK. You said in the receiving member state, but of course the United Kingdom is no longer a member state.
That's true. But in how far is that a problem for me?
No, I'm just saying. I'm asking you. Do you think the Court of Justice got it right? I'm inviting you to say the court.
Well, that is a different question. Well, I think the Court of Justice. Well, I came across an article dealing with something completely different with all these citizenship cases and all that. I said the headline was the judges read the newspapers as well, or something like that. And I think that is probably the answer. You know, judges are not immune to politics. I think. I mean, it would actually be more interesting, or as interesting, because this was a pre-Brexit case, of course, pre-Brexit, 31st January 2020 case. What would happen now that the UK is no longer a member state with no prospect of retaining its membership? Or what would happen in the Norwegian example, where we have Norway as a non-member state that now has something very similar, which will also work with mutual recognition, as far as I know. Is it correct to say, well, you have to challenge it there? That is a good question, because I mean, the basis for mutual trust is that we apply the same rules. We will apply the Charter. We apply the Charter as interpreted by the court. And if that is no longer the case, then I wonder whether that might be the right outcome. At the same time, that would mean that no non-member state could ever participate in mutual recognition measures, which of course is not an argument, but that's the consequential side. Well, I suppose it's a good question. I mean, I have to think about it a little bit. I mean, I think what the court would argue, and I think there's some force behind it, is they're at least all bound by the convention. You know, as long as everyone is in the convention system, there is this kind of minimum floor that we all have in common, and that does the trick. But I'm not sure whether that would apply if Turkey was that mutual recognition partner.
Yes.
Oh, thank you very much. The question I have is with regard to the suggestion that perhaps certain types of convention rights may not be reviewed by the Court of Human Rights, and at least that sounds a bit like an ouster clause. So I'm just curious as to whether or not the Court of Human Rights they would take a very interpretive approach to disable that even a very broad exemption, that they would still in effect say that, oh, but this is a human rights case, so the court would still have jurisdiction.
Yeah, that's a good question. I mean, it's a very good question, because I mean, there is the European Court of Human Rights has a track record in that respect when it comes to reservations. And there's, you can sign up. That's a great thing about international law. You can sign up to all sorts of things, and then you put in reservations, so it doesn't mean anything to you. And there are lots of reservations to the ECHR and various protocols, and the European Court of Human Rights is very, very strict when it comes to their interpretation. As a general rule, however, I mean, if it says there that a member state cannot be held responsible for reviewing human rights compatibility of another member state, it would be very difficult to get around that, I think. And don't forget, the European Court of Human Rights is probably not the most confident court right now. It's under a lot of pressure politically, and they're very much aware of that. So I'm not sure that, I wouldn't put all my hopes on the European Court of Human Rights bailing you out. It's not a constitutional court like the Court of Justice that can just say, well, this doesn't bind us because it's contrary to the treaties. Why? Well, we just made it up. That's not how it works.
Why do you say that the Court of Human Rights is not a confident court?
I think, well, I mean, they go through phases, I suppose, but I think if you look at certain developments, I mean, for a while in the UK, leaving the convention was a big deal, was a big argument. That was picked up very much in Russia, and was picked up in Turkey. And I think the Court of Human Rights, I think there is an acute awareness of the whole system, that the whole system can just crumble down very, very quickly. I think that is their fear.
Thank you.
Yeah, just a point of clarification. Could you just explain one more time how the Accession would limit the rights of asylum seekers that they enjoy under the MSS?
Well, I mean, I don't know what they're going to do now if they start renegotiating the accession agreement. But the Commission will want to make it bulletproof. Yeah? So they will want to negotiate a clause that will basically mirror the demands of the Court of Justice in Opinion 213. Because in Opinion 213, I mean, I didn't explain that, but the opinion procedure under the EU treaties is about whether an agreement, whether a treaty that the EU concludes with the outside world is compatible with EU law, with the EU treaties. Yeah? And the ECJ said this is not compatible with the EU treaties. And unless we change the EU treaties, it won't be. So if we have a clause that says you cannot review mutual recognition cases, then in MSS, the fella would come to the European Court of Human Rights and say, look, my human rights are being infringed because, I'll be sent to Greece in 2 weeks' time on this plane. I know this will happen, and I know that my Article 3 rights will be infringed. Yeah? Let's assume that is the case. The European Court of Human Rights will look at its jurisdiction, and it'll see that, this is an EU member state, and they're sending them to another EU member state. And the clause says we cannot review this measure, and therefore, no jurisdiction. That's what would happen, I think.
Any other questions? It's just that we're probably running out of time. Well, in which case, thank you very much indeed for a very rich and interesting presentation, and really quite technically astute as well as covering a lot of really important ground. So thank you very much indeed. Could you join me in my full thanks to